Webinar from the Field Fisher team here in Silicon Valley. Today we'll be talking about accountability under the GDPR. It's quite a buzzword at the moment, and we'll be focusing on data protection impact assessments. I should mention that we are re-recording this session. We broadcast this morning, but unfortunately, due to technical difficulties, our colleague in London, Megan, was unable to join. So we're recording this session so you have it complete. My name is Richard Lawn. I'm an associate at Phil Fisher, and I'm joined by my fantastic colleagues, Mirena Taskova.
Hello, everyone.
And Megan Ward, who is dialing in from London.
Hi, everyone.
So to give you an overview of today's session, Mirena will start us off by looking at accountability under the GDPR and refreshing our memories as to what that's all about. And then we'll take a dive into DPIAs, when the processing of personal data may be considered to be high risk according to the GDPR, and the triggers for conducting a DPIA according to the European Data Protection Board, or the EDPB. And we'll also consider the various DPIA blacklists that have been published by the national regulators. We'll then finish up by talking about what a DPIA should look like, the types of questions it should cover, and also our top tips for completing a DPIA as well. So to kick things off, I will now hand over to Mirena.
Thank you very much, Richard. I would like to start a little bit discussing actually about the new services and new products and new technologies that could require data protection impact assessment and why. As you know, the GDPR has several fundamental principles, and these fundamental principles should be your guidance when you want to implement any type of new service, new product, or technology, which should be in compliance with the GDPR. I would like to mention these principles, and these principles are: be transparent, use data for specific purposes, make sure that the data is accurate, don't use more data than you need. And these principles are great and they can be your guidance, but eventually you should be able to show that you are in compliance with these principles, either within the organization or to the data protection authority, or maybe to other third parties. And this is the principle of accountability. But accountability is much more than a combination of documents and operational practices. It is actually being able to evidence that those policies and procedures are working in practice. And this is where the data protection impact assessment is important. Basically, this is one of your tools to show that you are in compliance with the GDPR and these fundamental principles. Some data protection authorities publish guidance on accountability, such as Finland, France, the Netherlands, and the UK. And these guidances cover very important aspects of the GDPR, which include the data protection policies, maintaining records, but also data protection impact assessments. And since this principle of accountability is a whole and its entire other topic that we wouldn't be able to cover today, what I would suggest is please go to our website and our privacy blog. There are two very helpful articles on accountability that you would be able to use and help you with respect to accountability principle. Also, since you might ask some questions, we will be very happy to answer your questions, and we might create an additional podcast which would be focused especially on data protection impact assessments and your question in this respect. But now I will let Megan, hi Megan, discuss a bit. Hi. I will let Megan to discuss a little bit more about the data protection impact assessments.
Thanks, Mirena. So what is a data protection impact assessment? It's a formal process to help a controller of personal data identify and minimize data protection risks to individuals resulting from a particular processing activity. And the Article 29 Working Party, now the EDPB, guidance explains it's a process designed to describe the processing, assess its necessity and proportionality, and help manage the risks to the rights and freedoms of individuals resulting from the processing of personal data by assessing those risks and determining measures to address those risks. So a DPIA may address a single data processing operation, but one assessment could be used to assess multiple processing operations in terms of nature, scope, context, purpose, and risks. And if we just look at the second part of that definition highlighted in bold, a DPIA must be a genuine assessment of the risks from the data subject's perspective to their rights and freedoms. And so the primary focus is on data protection and privacy risks, but the EDPB guidance explains that risks to all rights and freedoms should be considered, such as freedom of expression, freedom of speech, and prohibition from discrimination. Moving on to the next slide, just before we cover when is a DPIA mandatory, a couple of points. Under Article 35, it's the data controller who's ultimately responsible for ensuring a DPIA is carried out. But in line with the Article 28 requirements, the processor should assist the controller with this obligation. A DPIA must be carried out before you begin the processing, so you also need to look at your existing processing operations, and because it's a continuous process, you need to review it regularly to consider if the facts that you use for the assessment have changed. If you have a data protection officer, they should be consulted in the process and their advice should be documented. Also, where appropriate, the controller must seek the views of data subjects. And the guidance, EDPB guidance on this states that the controller should document any decision to deviate from the views of the data subjects or its decision not to seek their views. Say, for example, because you determine that it's disproportional and impractical to seek their views. And finally, in certain circumstances, you may also need to consult with the relevant supervisory authority. So going on to one of the most important questions, what type of processing is likely to result in high risk? And there are three sources to look at to interpret this question. Firstly, what is high risk under the GDPR? So as you can see on the slides, we've got these three set out here. Starting off with systematic and extensive evaluation based on automated processing, which produces legal or significant effects on data subjects. So there's no definition of systematic in the GDPR, but guidance suggests that it means organised, methodical, or processing that takes part as a general plan for data collection or carried out as part of a strategy. And looking at the definition of extensive, it's more in respect of the area it covers, the amount of data or number of individuals. Secondly, we've got the large-scale processing of special category data or data relating to criminal convictions and offences. Again, there's no GDPR definition for large scale, but factors to consider include the number of individuals, volume and variety of the data, duration of the processing and the geographical extent. So say, for example, a hospital processing patient data would fall within this category. And thirdly, we've got systematic monitoring of publicly accessible areas on a large scale. Again, we've got the systematic and large scale elements here, which mentioned there's no GDPR definition. And an example of this would be, say, tracking individuals using a city's public transport system. So if processing activity fits into one of these criteria, processing is high risk and a DPIA would be mandatory. So now I'll hand over to Richard, who will cover the second source that you need to consider when determining whether your processing is high risk.
Thanks, Megan. So we've looked at high risk processing according to the GDPR, and we have these three examples under Article 35, and there's also some commentary in the recitals. But apart from that, we don't have much further indication from the GDPR about when processing may be considered high risk. But the EDPB has issued guidance. It was originally issued by the Article 29 Working Party, the EDPB's predecessor, in 2017, but it has been endorsed by the EDPB. That's guidelines WP 149. And I know I'm throwing a lot of alphabet at you right now, but that's the way that data protection goes, I'm afraid. So we have these guidelines, and probably the most important part is this section dealing with the criteria which determine when processing is likely to result in a high risk. And the EDPB have identified 9 such criteria, which are on screen right now. The guidelines say that, generally speaking, a DPIA will be required if at least 2 of these criteria apply. But, and the guidelines do put this in bold, in some situations, a DPIA may be required if only 1 of these criterion apply. So it really is fact and context dependent. It depends on what you're doing, and you need to consider each activity in isolation. So let's look at these criteria one by one. We have in the upper left evaluation or scoring. That's quite a broad description really, but that's where you're using personal information to evaluate a person's behavior or activities, create a profile of that individual, or apply a score. An example might be a financial company carrying out credit checks or AML checks on a prospective client. Or, for instance, it might include a biotech company using genetic tests to assess health risks or create a health profile. And finally, it might include a marketing company that's actually building profiles of their users or visitors to their digital properties. The second criterion is automated decision making, and this one's quite narrow. Here we're just talking about automated decision making according to Article 22 of the GDPR, which, as I'm sure you're aware, is about processing which involves decisions that are taken automatically and which have a legal effect or similarly significantly affect the individual. And there are restrictions in Article 22 of the GDPR about conducting automated decision making. The third criterion is systematic monitoring. So this includes monitoring of physical spaces through CCTV and cameras, or it could include monitoring through digital networks and online activities. I think the point that is brought out in the guidelines here is that the risk is that individuals are not aware their behavior is being monitored and cannot avoid it in some cases. So that's what might lead to a high risk. Moving on, we also have sensitive data or data of a highly personal nature, perhaps unsurprising that this is included. So here we're talking about special categories of data according to Article 9 of the GDPR. Those are data sets like health data, racial or ethnic origin data, information about a person's sexual orientation, all of those which are listed under Article 9. But we are also talking about other forms of sensitive data. So think about financial data or confidential communications or information about a person's private life. Some examples might be if an e-reader has a note-taking feature and a person is able to input personal notes, or perhaps an app that tracks aspects of somebody's life, a nutrition or a fitness app, for example. Then on the far right-hand side, we have large-scale data processing, which Megan already discussed. And on the second row, we have matching or combining data sets. Now, this is quite a broad concept, and the guidelines don't say that any form of matching or combining is going to require a DPIA. What they focus on is where different data sets have been obtained and then matched or combined in a way that would exceed the individual's reasonable expectations. So basically, if you have obtained data, for instance, from different sources, and then you're using them in an unexpected way or outside the bounds of what you would reasonably expect, then that could lead to a high risk. Moving on, we have vulnerable data subjects. So these include groups like children, the elderly, mentally disabled, but it could also include, in some cases, your employees. And that's not to say that every time you're processing employee data, you're going to need to conduct a DPIA. It's just one criterion after all, but it is something that the EDPB specifically pick out. New technologies or organizational solutions. Now, this is an important one and a real focus in the guidelines, and it's mentioned numerous times. Here, we're not just talking about new technologies per se, for instance, Internet of Things or something like that. We're also talking about novel applications of technologies in existing scenarios. So for instance, if you are considering installing CCTV cameras in your workplace, which is also accessible to members of the public, then that could engage this criterion here. And last but not least, we also have denial of service and denial of a contract. So for instance, oh, sorry, that's Megan just dialing back in. Yeah, she's just coming back online. The last but not least, we have denial of a service. So that's where if you are conducting processing and you are actually going to prevent the individual from accessing a service, or you're going to impact on their contractual rights, something like that, then you might need to consider conducting a DPIA. So moving on from this slide, that gives you an overview of the EDPB criteria. We also have a third level to consider. So under Article 35(4) of the GDPR, the national data protection regulators are also required to issue lists of processing activities where a DPIA will be necessary. And really, this is an area where national states can derogate from the GDPR and can set their own requirements, so to speak. So far, 22 blacklists have been published. A number of countries haven't done so yet, but are intending to do so. Also worth mentioning, under Article 35(5) of the GDPR, national regulators may also issue lists of the processing activities where a DPIA is not required. These are the so-called DPIA whitelists. Perhaps unsurprisingly, as this is not a mandatory requirement, there aren't many of these that have been published. Only a few countries have actually done so. But it's useful knowing about in case this expands in the future. So what we're going to talk about now and focus on for the next few minutes are these DPIA blacklists. What we've done is we have reviewed all of these 22 blacklists that have been published. Yes, we really have done that. That's what we do just in our spare time for fun. And what we've tried to pick out here is a description of the most common scenarios that appear in the blacklists. That's not to say that these scenarios here are how the regulators have exactly described or set out the scenarios. It's just to give you an idea of the types of things they're thinking about and they're looking for when talking about DPIAs. So you'll see that we have a few scenarios which duplicate or overlap with the GDPR and the EDPB criteria. So we've got our favorite large-scale processing, new technologies, profiling, things like that. But we also have some examples where the regulators either enter some new territory or actually more specific than the criteria. I'm thinking about in particular location data and tracking. That one features quite a lot across all of the national lists. We also have activities like employee monitoring and public surveillance. Here's an interesting one, invisible processing. So that's where a controller is not obtaining information directly from the individuals and is relying on an exemption under Article 14 in not providing notice to individuals about the processing activity. If you'll recall, that exemption applies where providing notice would be impossible or involve disproportionate effort. And essentially, the result is that the processing is behind the scenes. The data protection isn't, the data subject isn't given notice, so it's invisible. And that particular scenario appears in a few of the regulator lists. There are some interesting outliers as well, apart from these more common scenarios, and I'll just spend a minute or two calling some of these out. So some of the regulators actually focus on particular types of data, not just biometric, genetic, and other sensitive categories, but they talk about financial data, or they might talk about particular actions as well. So for instance, the Polish DPA call out transferring data outside of the EU, and the Czech regulator calls out processing publicly available data. It's interesting to see some of the different approaches here. And finally, some of the regulators actually call out particular technologies. So in the lists published by the Netherlands and Norway, they actually feature the Internet of Things, and the Hungarian list features smart meters too. So to give you a little better idea and understanding of these national blacklists, we've put together this table. This just includes a few of the countries which might be of interest to you. And we've put these descriptions along the top line. These are the descriptions that we've come up with. And again, they don't necessarily describe exactly how they're contained in the national blacklist, but they give you a sense. The other thing to mention about this table is we have ticks and crosses. So the ticks symbolize where a DPIA will be required if this scenario applies, or that scenario features predominantly in the list. So you could consider it a crucial component. And then we also have these crosses against the purple background, and that indicates where a regulator explicitly says that this criteria will trigger the need for a DPIA, but only if another criteria from the EDPB guidelines also applies. So again, all of these regulators take a slightly different approach, but what we've tried to do here is kind of give you a good summary view. Looking at the bottom line, the United Kingdom, quite an interesting one, because you can see in a few cases it only requires a DPIA if you also have these other EDPB criteria also applying, but it does give some particular importance to certain activities like profiling and evaluation, like combining and matching data sets and vulnerable data subjects. It's interesting also to note the UK is one of those regulators that calls out invisible processing as well, and a few other examples as well. So what I'll do now is hand over to Morena, who'll talk through a couple of these other countries we have on screen right now.
Thank you, Richard. This was really helpful. I would like to cover France, Ireland, and Netherlands, since these countries are quite popular within actually our network, and I see that there is quite a lot of work with the data protection authorities there. So I was thinking that might be helpful to cover. As you can see, our colleagues were really helpful from the other offices to publish several other countries like Italy or Germany, and later on Megan will speak a little bit more about Germany. What I would like to mention here is the following. As you can see on the top columns, like large-scale processing, new technologies on the table on the slide 9, it's very much like what is written in slide 8, which is the national DPIA triggers. And this is what we actually have in common with these data protection authorities. When I speak about the activities that require data protection impact assessment, we should definitely focus on this specific type of criteria. For example, for all of the 14 processing operations that set out in the French DPA's blacklist consist in combining at least 2 already determined criteria out of the 9 criteria that have been set by the European Data Protection Board. In other words, a single EDPB criteria never seems to trigger a data protection impact assessment on its own. Lists include 14 categories of processing operation, which may be broadly classified into the following categories, which I already mentioned. For example, if you can see the second column, large-scale processing, France definitely includes that. But in this case, you can see there is not only large-scale processing, but it's also location. So we discuss about large-scale processing of location, which is column number 5, location data and tracking. We also have profiling. If you see column number 4, profiling and evaluation. This includes profiling for human resources management purposes, profiling based on external sources, monitoring of contractual breaches, profiling which may result in the exclusion from the benefit of a contract. We also have monitoring, which is, for example, column number 7. This is constant monitoring of employees' activity. We also have alerts and reporting, which is mainly in the social and health sector. As you can see, very often the French DPA refers to vulnerable subjects criteria. This is 10 out of 14 processing operations refer to the vulnerable subjects criteria. And each time this criteria is combined with another criteria, which is usually with data of highly personal nature. In addition to that, we can discuss about what's happening in the professional sector, or that there is a processing of health data or so-called special categories of data, or in other words, sensitive personal data. This is, for example, when we have processing of health data for medical care, or processing of health-related data necessary for the establishment of data warehouse or record. I think that this is sufficient for France, and I would like to move towards Ireland. Ireland has similar activity. For example, we have again processing on a large scale. For example, use of personal data on a large scale for a purpose other than for which it was initially collected. Again, we have profiling. We have profiling again of vulnerable persons, or profiling of special categories of data, or profiling of individuals on a large scale. And to end with Ireland, we have biometric data profiling. In addition to that, I would like to mention the CCTV system. CCTV systems are very interesting and very often require data protection impact assessment. So please bear that in mind if you have CCTV systems in your facilities in European countries, consider performing data protection impact assessment. Another thing that I would like to mention about Ireland is that you have to definitely look in the Data Protection Authority website, or if you, for example, have operations in Ireland, or to look CNIL website if you have operations in France. And then if you, just to end with Netherlands, as you can see, Netherlands also focus on large-scale processing, on new technologies, on profiling and evaluation, on location data and tracking, as you can see from all the ticks that are on the table. And now I would let Megan continue with Germany and give our brief overview for Germany. And Megan, your turn.
Hi, Megan, are you still on the line with us? Okay, Megan seems to have dropped off. Some more technical difficulties there. We'll just try dialing her back in. What I think she was going to say is, we have this list here for Germany, but it should be noted this is an overarching list that has been published for all of Germany. But as you may be aware, there are actually 16 regional data protection regulators in Germany, and each of those either have or will be publishing their own list. So that adds a different level of complexity when it comes to Germany. Megan, are you with us now?
I have a few technical network issues.
Fantastic. All right, handing back over to you now.
Thanks, Richard. So moving on, we're going to cover what does the DPIA look like. So the GDPR sets out the minimum content, which you can see on the slide. So that should be description of processing operations. You need to understand what data will be processed, why and how, an assessment of necessity and proportionality of the processing, assessment of risks to the rights of data subjects, and mitigating measures. And so, Morena, what does that mean in practice?
Hello. I would like to speak a little bit about when actually do we need data protection impact assessment. And Richard will help me there. Megan, please jump in if you feel the need to jump in. But basically, we need data protection impact assessments prior to the processing, and the DPIA, as I already mentioned in the beginning of this session, should be seen as a tool for helping decision-making concerning the processing. And also, please make sure that you start with the data protection impact assessment if such is actually necessary and it's not part of the whitelist, Make sure that you start as soon as practicable in the design of the processing operation, even if some of the processing operations are still unknown. I would assume that you would have to update the data protection impact assessment throughout the life cycle of projects, so you can ensure that data protection and privacy are considered. And also, it might be necessary to repeat individual steps of the assessment as the development process progresses, because the selection of certain technical and organizational measures may affect the likelihood of the risk or the severity of the risks posed by the processing. As to end here, I would just say that the data protection impact assessment is an ongoing process, especially where the processing operation is dynamic and subject to ongoing change. But I will let Richard to continue and tell us a little bit more of who is responsible again for data protection impact assessments.
Yeah, so to reiterate a point that Megan made earlier, it's ultimately the controller who's responsible for carrying out a DPIA as part of its own compliance responsibilities. But a processor will also need to assist a controller where necessary with that. And hopefully within your contractual arrangements with processors, you have a requirement that they do provide assistance where needed. Now, we've talked quite a lot today about when a DPIA will be needed, and we've looked at the GDPR, the EDPB, and these national blacklists. I think really the point that comes across is that there's a certain amount of complexity on this question, and there are a lot of sources to look at. So really, you've got to be thinking about where are you doing the processing and whose data will be affected. If you're only looking at one country, then you can obviously consult that. I also want to look at multiple countries lists depending on what you're doing. Okay, what we can spend a few minutes talking about now is what should a DPIA look like? What information and questions should it include? And what we're going to be first starting with is actually and the minimum requirements that are set out in Article 35(7), which Megan should hopefully take us through right now.
Thanks, Richard. Yes, as you said, GDPR sets out the minimum content, and that covers, as you can see on the slide, description of processing operations. So you need to understand what data will be processed, why and how. That includes purpose of processing and legitimate interests. Secondly, the assessment of necessity and proportionality of the processing, and assessment of risks to the rights of the data subjects, and then the mitigating measures. And each supervisory authority is published, most supervisory authorities have published templates. But Morena, what does this actually mean in practice?
I would say here, when you decide to do data protection impact assessments, make sure that you have all these details that are listed in the slide, which is nature and scope, context and purpose of processing. What lawful ground are you relying on? What notice and choices do individuals have? Who else is involved in the processing? And everything else that it has been mentioned in this slide. But what is the most important for the data protection impact assessment is first to assess, do you actually need it? And that was the purpose of our entire webinar, is when do we need data protection impact assessment, and how can we assess that we need data protection impact assessment? And just to end here is my note here would be, make sure that you know that what are the criteria of the European Data Protection Board, and then focus on the blacklist. And I will let Richard.
Yeah, it's also worth noting that the GDPR doesn't actually prescribe what a DPIA should contain. So it's actually up to you. Obviously, it should meet those minimum requirements, but then it's up to you whether you use one of the templates that's been published by the regulators, or whether you actually create your own based off of one of those templates. And you can consider tailoring it to your own business. So for instance, you might want to include questions around the use of cookies and tracking technologies, because those will engage e-privacy rules as well as the GDPR. You may also want to include questions around direct marketing, which again engage e-privacy rules as well. And then if automatic decision making is something that might affect your business, if you're potentially screening users or candidates in any sense, then you should be looking at including some specific questions around those issues. The other thing that's important to include is not just identifying these major topics and questions, but also how you're going to mitigate the risks. So talk about what security measures you put in place. How have you provided notice to individuals? And really important here, how are you going to respond to and respect data subjects' rights? How are requests going to be handled? And a final part of the DPI really is to conclude what is the risk level now and is it acceptable? Can you proceed with the processing? If a high risk remains despite the mitigating measures, then you may need to consider consulting with data subjects and even the supervisory authority in appropriate cases. Now, we actually got 3 top tips to kind of wrap up with. The top tip number 1, I'll take that. So consider whether you need to actually create an initial short form assessment to determine whether you need to conduct a full DPIA at all. I've actually been involved in a number of DPIAs, and it is a lengthy and involved process. It takes some time and it really ekes out a lot of different questions that you need to consider. And in a lot of circumstances, you might not actually consider that a full DPIA is necessary. So what this short form assessment can do is it's something that can be used by the business without need for further guidance, just to see whether actually you need to then consult legal and complete a full DPIA. Morena, I think you've got top tip number 2.
Thank you very much, Richard. Very important tip actually, and this is who is going to prepare the data protection impact assessment within your organization. And early input from business and product team is important for the assessment, whether a data protection impact assessment is needed and how the data protection impact assessment would be prepared. Make sure that your data protection officer, if you have such, is aware that you are preparing a data protection impact assessment, of course, with the help of internal or external consultants. And then one last thing that I would like to mention, which Richard already started, and this is about that there are templates of the data protection impact assessments from different authorities, and they are very helpful to as a starting point. But if you do a global data protection impact assessment, then you might consider some kind of more general approach.
And then Megan, to finish off, we have our final top tip.
Yeah, number 3 for me is to remember that the DPIA is a process and not a one-off exercise. So I know we've mentioned this quite a few times, but they are living documents and should be regularly reviewed. So if the process is subject to change, new technology is being used, or if the purpose has changed, then you should be reviewing your DPIA. So thanks very much for tuning into the re-recording today. Invites for our next webinar will be on the way soon. And I believe, as Morena hinted to at the beginning, we've got some exciting news on the way about our upcoming podcast series.
Make sure that you follow our next webinar, which would be comparison with GDPR and the Brazilian law.